Today we will discuss about subagent under the contract of agency. The question may be asked from this topic. When agent can delegate his power to subagent. What is delegation of power of agent? Section 192. Examine the agent's responsibility for subagent. Examine subagent's responsibility to the principal. What is proper and improper delegation of power by agent? Section 193. What do you mean by substitute agent? Section 194 and 195. The general principle is, a delegate cannot further delegate. Delegatus non potest delegate. An agent, himself being the delegate of his principal, cannot further delegate his powers. Section 190 says that an agent cannot lawfully employ another to perform acts which he has expressly or impliedly undertaken to perform personally. However, under certain circumstances the agent may delegate some or all of his powers to another person. Who is a subagent? As defined under Section 191. A subagent is a person who is employed by the original agent and works under the control of that original agent. In the business of agency, let's understand this in a simpler way. A person will be called a subagent only when two conditions are satisfied. First, he must be appointed or employed by the original agent. And second, he must act under the control and supervision of that original agent while carrying out the agency work. So remember, employment by the agent and control by the agent are the two essential elements of a subagent. Now, let us understand in which situations an agent can appoint a subagent. As a general rule, an agent cannot delegate his authority unless he is expressly allowed to do so. However, there are certain important exceptions. First, when the ordinary custom of trade permits the appointment of a subagent. Second, when the nature of the agency business itself requires such an appointment. Third, when the work to be done is purely ministerial. That means it involves no discretion or personal judgment. For example, routine clerical work or assistance. Fourth, when the principal has agreed, either expressly or even impliedly, to the appointment of a subagent. And finally, when there is an unforeseen emergency, where appointing a subagent becomes necessary. So, these are the key situations where an agent is legally permitted to appoint a subagent. Now, let us discuss the effect of appointment of a subagent. Under Section 192, when a subagent is properly appointed, the principal, in relation to third persons, is represented by the subagent. This means, the principal is bound by, and is responsible for, the acts of the subagent, just as if the subagent were originally appointed by the principal himself. In simpler terms, if a particular act had been done by the original agent, the extent of the principal's liability would be the same. And that same extent of responsibility applies even when the act is done by the subagent. However, remember this carefully. All of this applies only when the appointment of the subagent is proper. So, proper appointment is the key condition for holding the principal responsible. Now, let us understand the responsibility of an agent and a subagent. First, are the agent's responsibility. The agent is responsible to the principal for all the acts of the subagent. This means, if the subagent makes any mistake or commits any act, the agent will be answerable to the principal. Now, for coming to the subagent's responsibility, the subagent is responsible for his acts to the agent and not directly to the principal. However, there is an important exception. In cases of fraud or willful misconduct, the subagent becomes directly responsible to the principal as well. In simple words, normally, the subagent answers to the agent. But in serious cases like fraud or intentional wrongdoing, he is also liable to the principal. Now, let us discuss the situation where a subagent is appointed without authority. Under Section 193, when an agent appoints a subagent without having the authority to do so, then the legal position changes completely. In such a case, the agent stands in the position of a principal with respect to that subagent, and the subagent is treated as if he is the agent of that agent and not of the original principal. As a result, the agent becomes personally responsible for all the acts of the subagent, not only to the principal, but also to third parties. At the same time, the principal is not bound by the acts of such a subagent, and importantly, the subagent is also not responsible to the principal. Let's simplify this. The relationship between the agent and subagent becomes similar to that of a principal and agent. The subagent represents only the agent, and not the original principal. The agent bears full personal liability for the acts of the subagent, and the subagent is accountable only to the agent, not to the principal. Now, let us understand the concept of a substituted agent. Under Section 194, when an agent has express or implied authority to appoint another person to act on behalf of the principal, and the agent accordingly appoints such a person, then that person is not a subagent. Instead, that person becomes an agent of the principal for that particular part of the work which is entrusted to him. Let's simplify this. If the agent has the authority to nominate another person on behalf of the principal, and he actually makes such a nomination, then the new person steps into the role for that specific task. In other words, he substitutes the original agent for that particular work. That is why he is called a substituted agent. And remember, he is directly responsible to the principal, not merely to the original agent. So, a substituted agent is not a subagent, but an independent agent of the principal for a specific purpose. Now, let us understand this concept with the help of illustrations. Illustration A. A directs B, who is his solicitor, to sell his estate by auction, and also to appoint an auctioneer for this purpose. Now, B appoints C as the auctioneer to conduct the sale. In this case, C is not a subagent, but C becomes the agent of A for conducting the auction. Illustration B. A authorizes B, a merchant in Calcutta, to recover money due from C and Company. Now, B appoints D, a solicitor, to take legal action for recovery of that money. Here again, D is not a subagent, but D acts as a solicitor for A, that is, an agent of the principal. So, in both these cases, the persons appointed are not subagents. They are substituted agents, directly working for the principal. Now, let us understand the duty of an agent in naming a substituted agent. Under Section 195, when an agent selects a substituted agent, he must exercise the same level of care and judgment as a person of ordinary prudence would exercise in his own case. In simple words, the agent must act carefully and choose a competent and reliable person. If the agent does this, then he will not be responsible to the principal for the acts or negligence of the substituted agent. Let's understand this with examples. Example A. A instructs B, a merchant, to buy a ship for him. B appoints a ship surveyor, who has a good reputation, to select the ship. However, the surveyor acts negligently and chooses an unseaworthy ship, which is later lost. In this case, B is not responsible to A because he acted prudently, but the surveyor is responsible to A. Example B. A consigns goods to B, a merchant, for sale. B appoints an auctioneer, who has good credit, to sell the goods, and even allows him to receive the sale proceeds. Later, the auctioneer becomes insolvent and fails to pay the amount. In this situation, B is not responsible to A because he had exercised due care while appointing the auctioneer. So, the key takeaway is, if the agent acts with reasonable care and selects a trustworthy substituted agent, then he will not be held liable for that person's negligence or default.